Good evening, everyone. IndoUS Chamber of Commerce of Northeast Florida welcomes you to the immigration event. New Year administration, New Year, and what will our process looks like, an immigration process will look like in 2021. Before I get into the details of the event itself, I thought let me share a few words about our chamber. Let me quickly share my screen. IndoUS Chamber of Commerce is a nonprofit organization with a vision to create vibrant growth for and facilitate access to Indian American businesses and professionals. Our mission is to provide an active networking forum among Indian American professionals, business owners, and organizations in Northeast Florida who can advance their interest by exchanging ideas and promoting professionalism through education and community involvement. We are ranked number 5 under Business Networking Organization category by Jacksonville Business Journal. It has been a wonderful journey seeing our organization grow organically so far. We have more than 3,500 website visitors, and our email list and the chamber members, we have around 700 members. So we have seen the chamber grow organically for past several years. Thanks to our sponsors, SGS Technologies, Bystar Credit Union, JEA, Florida Blue, Insurance Wagon, Blue Star Pet Hospital, Deerwood Jewelers, thanks everyone for your sponsorship. We were able to host several events, especially online events during COVID-19 crisis. Thanks for your sponsorship, and thanks to our speakers, sponsors, and even our chamber members and also our leadership team. Without any further delay, I would now introduce a moderator for the immigration event, Lakshmi Balasubramanian and Dr. Amit Vedre. Please welcome Lakshmi and Amit.
Thank you. Thank you, President Amuda. Thank you so much for having me here to take care of this immigration event with our immigration expert. So today's event is going to be one of the important topics that we all have been looking forward to with regards to what change is happening in immigration. And I have a great expert with me today who works at JMG Law Firm at Atlanta. And she is not only professionally connected with me, but also a very, very good friend of mine. And I'm thankful to have her here to help the organization and, of course, the people who are viewing this to understand what immigration changes are coming up. So let me give a few words about her. On the professional side, as I said, she works for JMG Law Firm, and she had been in the corporate industry and being a lawyer for almost 15 years now. And she also is a Gator. So if there are Gator fans, yes, she's a Gator. And she got her doctorate of law, or JD as it's called, Juris Doctorate from Stetson University. So she is called the Doctor of Law. As I Googled, what does JD stand for? That's what it says. So we have a great expert today to help us understand the immigration side. So on the personal side, something very important to note about her lineage or kind of association with the legal life or the lawyer life is her great grandfather was a person involved in writing the Constitution of India. So I think she takes it all from there. So please welcome Lalita Alladi here, who is going to be here helping us understand the immigration changes or process with regards to employment, employees, as well as on the family side. Welcome, Lalita.
Thank you, Lakshmi, for that very kind introduction. And thank you, President Amuda and Dr. Amit as well for welcoming me here today, and to everyone here at the IndoUS Chamber of Commerce of Northeast Florida. It really does seem like a wonderful organization and a huge network. So thank you for inviting me.
Thank you. You're most welcome. You're most welcome. So today, I know it's going to be strange for us to ask a question to lawyers. I'll be honest. So we are going to go into a conversation mode, trying to understand how the immigration are impacting employees, as well as the family base. So I'm going to navigate on the corporate side because I think I'm close to corporate. Dr. is close to people. So he's the family side of the house. So I'm going to start with understanding. Tell us what's happening. What's the latest on the employer-employee side of the house with regards to immigration changes? Anything we have to know about the green card processing, or even go to the level of H-1B or to the L-1 and the B1 visas too?
Okay. Yeah, there are definitely a lot of changes. First of all, let's talk about the one that most Indians are concerned about That's H-1B, right? Many of us are very familiar with H-1B. That is used by us the most, mostly because the green card processing for most Indians takes so long. The H-1B is a wonderful tool to fill the gap until you receive the green card. So we know that, first of all. But what type of recent changes have we had? First of all, this is not a recent change, but if you were trying to apply for an H-1B, today was the last day to register. if you were trying to file for this year. But every year, as you know, there is a short period of time during which you can file. And in the last 2 years, that process involved registering first, being selected in the lottery, and then if you were selected, then you actually complete your entire application and turn it in. So first of all, that ended today. But some big news as far as H-1B is that we were really concerned that earlier last year and in the beginning of this year, that there was going to be a change in the H-1B world where it was going to become wage-based. The selection was going to be wage-based. So what does that mean? Wage has always played an important part in H-1B selection, in the sense that not selection, but in the processing, because that's one of the factors that you would have, one of the things you'd have to fill out and provide to show that you are eligible for an H-1B. You have to meet a certain wage criteria. But the difference is, what they were going to do is, here people are getting selected in a lottery, right? We were already aware of that. And about 65,000 people get selected every year. And then an additional 20,000 people get selected based on master's degrees. But this year, they were going to make that selection based off of income. So you would literally be, they'd look at who makes more and then start selecting from the top. That just seems highly unfair. And we were very concerned that that was going to happen. And, the Trump administration had its, they had their reasoning behind it, but definitely we were not proponents of it as immigration attorneys, and definitely those who are filing. So luckily in February of this year, that was turned down. So that is not what's going to take place in this lottery that's going to begin as of today. It's not going to be a selection process that's done by wage. They've postponed doing it till December of this year. Now, what happens between now and December for the next year, we don't know. But for now, we know it's not going to affect this year's H-1B lottery because it's been postponed. So that's one big change, and a change that I think is important and helps most people. Okay, so that was one big change. Another big change will also be related to the family members. The family members of those who have an H-1B file for an H-4. They are the dependents, the wife, the husband, or the children. They get an H-4 dependent visa. Well, when President Obama was in place, he made sure that administration ensured that those spouses or children could have an H-4 EAD. So what that means is employment authorization document. And so that was very helpful. And it's not for anybody who has an H-4. I should also say that. It's really for those who already had a green card process started and they were far along and they'd made it to a certain part of the green card process. And once they reached that part of the process, and if they had an H-4, they could at that time apply for that employment authorization and work during that time once it was approved. But again, the Trump administration came in and said that they wanted to rescind that H-4 EAD, and that was going to cause a lot of problem for families who had H-1B spouses or parents. And it's also going to cause a huge problem for the US economy, because especially in the Silicon Valley, you name it, Apple, Google, whomever, a lot of spouses are just as qualified as the original H-1B candidate. And by removing their work authorization, the companies are now going to have problems. Yeah. So that was something else that we were really worried about. Luckily, before that was formalized and rescinded and everything, actually that has been dropped. So the H-4 EAD is still safe for those who were eligible. So that's another big piece of news for those who are that type of employment visa.
Good, good, good. Thank you, thank you. I mean, I know many times we think about these processes as like, hey, administrative filing and everything, but we don't realize the impact of economy or impact of the government into it. Thank you for opening that thought process into us. But I'm glad H4 EAD is not rescinded, and there are more qualified people who can support the organizations or the corporate business in the United States, which is a good thing. So let us take a little more into the green card processing. So why there are changes, or why there is a delay in the green card processing filing? Kind of, I see there is nuances. People literally go investigating about, hey, where should I apply it from? Why should I apply it from here? Kind of
Okay.
help us understand that processing a little bit.
Okay. Sure. So let's talk about two things. One is a question I get often is about, hey, does it matter if it's this processing center or that processing center? Okay. So at least when we're talking about employment-based cases, and I looked it up today real quickly to make sure that this is still the case because it changes day to day. But if you were to file your employment-based green card case, right now, if you're just filing without premium processing, okay, all the cases are to be filed at the Texas Center. Okay, so there itself, if you're just filing without premium processing, we already know the timing is not related to the location because all of them are going to one location. Whether you're filing along with your second portion of the case, the I-485, or you're filing only your first portion, it doesn't matter. It's going to the Texas Processing Center right now. So we can tell right there that that's not what's causing the problem. Then you'll say, well, what about premium processing? When we're filing with premium processing, just for those who don't know, premium processing is just an additional fee you pay to the USCIS saying, hey, I'm willing to pay extra for you to just go ahead and process my case faster. I mean, they can still approve it, they can deny it, they can send it back and ask more questions, but they have a specific time frame, 15 days, in which they have to make a decision or send it back to you and say, send me more information. And if you respond, they still have only 15 more days to do it. So that's why you pay extra for that kind of fast decision. But the point is, if you go onto USCIS website for the employment-based cases right now, there are 4 locations, depending on where you live and certain criteria that you can send it to. But if you think about it, you're paying for a specific processing time anyway, the 15 days. So again, it doesn't matter which processing center you send it to. They are limited by the 15 days. And if for some reason they cannot do it within those 15 days, they refund your premium processing fee. So at least that part is fair.
Okay, that is good. That is good to know. Good to know. So tell me a little more about, hey, when do you decide about going with a concurrent filing or a sequential filing? I know you talked about the 140 and the 485 briefly, but that is a common question people on this side of the house before they make that decision about doing it. Help me, how should a civilian should make a decision about going with a concurrent or with a sequential process?
Okay. So again, I'll always give a little bit of background for those who may not know enough about immigration. So especially when you're filing an employment-based green card case, there are 2 parts. There's the I-140 and there's the I-485. These are the 2 portions that get filed with USCIS. So the I-140 is the employer's application petition to the government, and then the I-485 is for the employee themselves. So both parts are necessary. Yeah. So in some cases, you'll say, first of all, there are also different levels of green card cases. At this moment, or I should say most of the time, only the highest level of green card cases can file concurrently. Usually that is the case. For again, I'm only talking, right now I'm talking about your Indian nationals. But for the most part, your high level type of green card case, in those, you're eligible to file both cases together because the cases are considered current. What current means is green cards in that level are available, meaning so many green cards are issued per country per year. Yeah. And so for that top level type of green card, they are usually available immediately. So they call it current. And that means that those individuals are eligible to file together. But even then, you'll have to make a decision on whether it's wise to file it together or not. Because you may say you're a little bit unsure about your case, whether your I-140 is going to be approved, then you may not want to file the I-485 with it. You may want to just file the I-140 on its own, see how that goes, and then if it's approved, then file your I-485. So it's going to depend on the assessment of your case and the strength of your case, so that you don't get an unnecessary denial on your I-485 also. Okay, so that's what that's based on. But let's talk about what the majority of the cases are for most Indian nationals, and that is EB2, EB3 filings. Okay, those are the majority level 2 and level 3 category cases that are filed. Everybody would love to be EB1. Most people try to persuade you, oh, I'm an EB1, I'm extraordinary. You are extraordinary, but not according to USCIS. So if you're filing an EB2 or an EB3 level case, unfortunately, Indian nationals and Chinese nationals have a very long line to wait in. So you don't really have a choice in that. You'll only file the I-140, and hopefully it's approved. And when you file that I-140, you get the first day they get it, you get a priority date. That priority date is your ticket in line. And so you hold on to that priority date till that number is called sometime in the future, 6 years from now, 8 years, 12 years. We don't know, because the speed at which they are providing the green cards changes. It's a little bit more complicated than that, but that's the best way for me to explain it. And so when that number is called, that's when you are permitted to file the second portion, your I-485. So most people don't really have a choice if you're an Indian national, especially if you're filing for an EB2 or an EB3. I think you're on mute, Lakshmi.
No, that's a good point. No, thank you, Lalita. That is a good point where you mentioned about the timing and the process it takes. Given you mentioned EB1 and EB2, I'm going to ask a question, which, again, from an employer perspective. So I've come across employers where they opt for bringing in M1 visas and converting it into a green card processing for EB1 instead of a H1B. Can you help us understand that to an extent what we can understand?
Yes. Okay, so L1 visas are, first of all, intercompany transfers. Okay, so that means, so I worked for a company and we dealt with this a lot because we were a company that's internationally based, and we had offices throughout the world. So when we were ready to bring in somebody to the US, it's an intercompany transfer. They're just coming from, it doesn't matter. They might be coming from France. And so I said, oh, you're already employed in this manner there. You're specialized. And so we want to bring you here. And we want to know about your specialized knowledge. But L1 itself has two categories, okay? L1A and L1B. L1A is your executive or multinational manager. L1B is someone with specialized knowledge. Again, a majority of the people we bring in may have been for specialized knowledge. But those who are in that L1A category are managers or executives, or they're going to take on a position here as a manager or an executive, okay? So they're already qualified with that L1A up to a certain level in a way that already, I don't want to use the word pre-qualifies, but checks off many boxes for one of the types of EB1 green card that one could file for, okay? Because in the EB1 category, there's a multinational manager category. So the additional box that you have to check for the green card is that you are also a manager in your previous job in the previous country. Okay, so that may not be every L1A individual. They may be a manager now in the US, but they may not have been a manager in France. But for those who were, they might be eligible to file for that level of green card. So they can skip, instead of going through that whole H1B queue, they can go straight from L1A to EB1 green card.
Okay, good. That's good to know, because EB1 is always kept for PhDs or kind of unique specialization. So now that you mention it, it's good to know for intra-company transfer too.
Yeah.
Good. Thank you. That helps. And one other question that came to my mind while people are filing, because the common thing any civilian is going through when they do these immigration filing of documentation is, hey, I don't keep my documents well because everything is digital now. and they get anxious. It's. I mean, people go through that. How do
Yeah.
you tell them, like, hey, start? If you're going to be looking for green card processing or any kind of immigration activities, what are the basic, always to keep in hand, kind of basic documents?
Yeah. So when you say in hand, I just assume, if I'm going to be applying for an employment-based visa or green card, what I want to have in hand, and by hand I mean on my computer,
Yeah, that's right.
is when my employer asks for something, right? So they are going to say, hey, Lalita, we're going to apply for this for you. I want to have my birth certificate. I want to have a copy of my entire passport. I want to have a copy of my visa, my I-94 that shows when I have to leave the country, when my status expires. These are, at the most basic level, these are the main documents you need. But of course, you're going to need many other documents, but it's always good to have all of your immigration documents and need prior approval notices from prior visas, and denials too. I mean, anything you've received from, anything you've received from the consulate, anything you receive from USCIS, I would keep a PDF of it readily available. So if my employer's immigration team asks me, I'm not going to take 2 days to locate it. I'm going to say, oh, you want it? Here it is. And boom, they can start working on it. So I would have it readily available both digitally, and I'd keep all my originals in a safe place, because when you actually attend your USCIS appointment, if you get called for an interview, they want to see your original and you want to have a copy available to give to them as well, because you don't want them to take your original.
Makes
But
sense.
yeah, depending on the type of case, if it's employment based, those are the types of things you'll want. Any other student visa you held before, if you're a J1 visa holder, there are certain immigration documents associated. So for those types of cases, that's what you want to have on hand.
Okay, got it, got it. I have one last question on the employer-employee related, then I'm going to hand it over to Dr. Amit, who's going to talk from a family perspective.
Okay.
So I know you, 2 days ago when we connected, you mentioned you had been to USCIS, and I want to know, or tell us what we can know about what is the timing, or why does it take this much time for USCIS to process anything?
Okay. That is that's the question we all want to know. The attorneys too. Why? Why does it take so long to process, right? But jokes aside, put COVID aside for a moment. Before COVID, processing times have always taken a frustrating amount of time. Not only do they have so few officers compared to the number of applications they receive, but then you also have to think about, like, for example, the most recent thing, and you probably know about this, EB3 priority dates moved forward. And so people who had EB2 cases downgraded to EB3 because they could be processed sooner. And so you can imagine the huge influx of cases that came in when that advanced, to say, oh, okay, never mind. I know I was EB2 level, but now I want to go downgrade to EB3 just so I can get processed sooner. The huge influx of cases that happens, and this is just one example, means that mailroom has to filter through all of that. So normally we would say just the processing time alone is going to be long. But right now, because of COVID, they're also taking a long time just in the mailroom itself. So where we might say you will get a receipt notice showing that they received it in 2 weeks. Or if you haven't received it, a little trick we will say is, hey, have you seen that the check got cashed? If the check was cashed, then you
Yeah.
know they received it, right? But even that's not happening. For those who are applying for employment authorization, this has been the most frustrating thing in the past 6 months. Whether you were a student, whether you were a spouse, on a dependent visa, or anybody, the EADs, the employment authorization,
Mhm.
has been taking so long just for them to open it in the mailroom.
My
And
God.
so it's caused a lot of problems. And there's, in fact, a recent lawsuit filed either February or this month, I have to look, that's specifically pushing USCIS to explain themselves and say, now people are not able to work because their EAD was not extended purely due to their wait at USCIS. It's harming people, it's harming companies.
Hmm.
So, if you ask why, that's a really tough question. But now, to add on top of it, they have the COVID reason as well. People are working from home, so it makes it more difficult. So, yeah.
That's the reality, right? Yeah, I know
Yeah.
it is. It's been an anxious thing for many people. Hey, what's happening? Why? I mean, it's paper. Don't you have to just look at it and approve it, kind of thing? It. I mean, it's easy said, but I know it's a lot
Yeah.
of processing. Totally a
Right.
lot of processing because it's something
Yeah.
related to the country and everything.
Yeah.
And I'm going to hand it over to Dr. Amit. Amit, are you here? Yes. All right, we'll move
Yes.
on to the
Can you hear me?
family-based. Yes. Please,
Yes,
Dr.
we can.
That was a great discussion, Lalita and Lakshmi. Great questions. And just in case if there are any technical issues, please continue with the family questions. But as a quick overlap and transition, Lalita, are you able to hear me well?
I am. I am.
So one of the quick question we had is as a transition, and this is not necessarily a family-based question, but people who are in the EB1 category, will it help if they feel they are in the national interest to get letters from people in the jurisdiction, such as senators or congressmen? Do you think is that helpful?
I don't particularly find that to be helpful. That is a question we
Okay.
receive. I mean, people are anxious to get their green cards, and they'll say, "Hey, you know what? I'm actually very close. I know such and such senator," or I understand that if there are certain delays, we can contact a specific ombudsman or something like that. There are certain channels like the ombudsman and things that we may use, but knowing your own special contacts is of no consequence or help in this type of case. There's nothing that they can do to really move your case forward. Uh, so I wouldn't, whether you're a national interest case or not, unless for some reason you have the president themselves saying this is the person who is going to advance the COVID vaccines today. I highly doubt that the political influence is really going to be playing a big part.
Good point.
Okay, great. Thank you. One of the first, most common questions asked is I'm a naturalized United States citizen and I'd like to apply green card for my parents.
Yeah.
Is it better if I apply A in United States while they are here on a visitor's visa or while they are in India?
Yeah. Yes, that is a common question. Um, you really can't look at it too much as is it better to file here or there. It's just that you have two means available to you. Okay. And for a period of time recently, one was not available. So let me talk about that because of the recent changes. President Trump had, as we know, had various travel bans and um, proclamations that came through. Among them was one that was the purpose of which was to stop new green cards from being processed from outside the US. So that included, it didn't matter if you were an EB1, EB2, EB3 green card for employment based cases. It also meant family based cases. It could be your parents, your children, your brother, your sister, it didn't matter. So for a while there, you could not process those. And it was only, I want to say, in February of this year that President Biden lifted that. Okay. There is still one other proclamation still in place that has not been rescinded yet. And that affects that affects new H1Bs, J1s, and L1s and their dependents. Okay. But since we're talking about family based green cards, I just wanted to mention that there was a period of time right now that new filings were not being accepted for this reason. But that being said, um, if you're already in the US and you've changed your mind and you've said, mom and dad are here and we're thinking about it, mom and dad, you're getting older and we'd rather have you stay here, and this discussion ends up happening while you're in the United States, then it ends up happening while you're in the United States. Then you have the option of filing with USCIS and filing this country. But you don't want to come into the United States with that intention because the law specifically prohibits that. The law specifically says that when you are crossing that border, you cannot have an intent to immigrate. your intention is to be here only temporarily, because most likely you're coming here, the parents are here on a B2 visitor visa. That has a specific temporary temporary basis you're allowed. So with that intention, they're entering. Now, if they've already know they're in India and they're talking about it already and they're saying, no, we're sure we want to file for a green card, then it's best they file from there itself. So what that means is you file the first portion. In a family-based case, that first portion is called the I-130. That would be if we're talking about a parent case, that means the child is going to file the I-130 saying, I want to sponsor my parent. And then the parents, once that's approved, they will go to the US consulate in India and they will adjust status through the consulate there. And that means you are working with a different entity. You're working with the Department of State if you're doing it from another country versus USCIS here. Now, normally I'd say maybe the Department of State process could be faster, but now they have such a huge backlog because everything had been stopped. So you can imagine how many people are trying to get appointments. So most likely, all those that got backed up in the past year, they're all rushing to get appointments, and they probably still don't have many appointments available because of COVID. It's probably backed up and now is going to cause a lot of delays.
So when you said the Department of State, is that the Department of State in the country, the India?
Correct. So US Department of State that is located in India. So that's what we mean. Usually we just say the US consulate in India. So that's
right.
where you're going for your appointment. They have an interview there.
I see what you're saying. Got it. No, good point. Yeah. Thank you for clarifying that.
Yeah.
So the second part of the quick question, Lalita, is does it make a difference if they are not earning members now, but they have, I guess, they are not working? Do they have to have something as a minimum bank balance?
I am so glad you asked this question, because this is, no, I mean it, because this has been something that I find most upsetting. And of course, many immigration attorneys find most upsetting. And luckily, it's changed recently. So let me tell you a little bit about that. When you're filing for a green card again, let's just use the example of your parents, right? You want to file for your parents. You anyway have to file as that child what's called an I-864. You're going to say you're going to financially support them. Okay. And that's your affidavit swearing you're going to be responsible for them financially. Should they not be able to support themselves, you are signing a contract with the US government that you will take care of them when it comes to their financial liabilities, right? And that exists all the way up until the time they become US citizens if they decide to do that. So that itself is, you would think that is sufficient because you're telling the US government, I'll take care of them. But what happened is there's always been a public charge rule, but it has been enforced more recently and more strictly as of February or March of 2020. And this rule has caused a lot of problems. What happened is they conducted a 6-pronged test. Not only are you, the child, saying, I promise to support them financially and all that, but now the person who is applying for the green card themselves has to now fill out a new form called an I-944, saying that they will not be a burden to the US government in seeking public benefits ever. I don't know how it's possible for someone to know that, first of all. Okay. I mean, if you're sponsoring somebody and they're 60, how do they know? How does that 60-year-old know that at 85, something doesn't happen and they will need to rely on those public benefits? There's really no way of knowing it. So they have a subjective test. Okay. Subjective test. And it's a 6-pronged test. They say they're looking at these 6 criteria. And the criteria is as follows. And when I'm saying it, I want all of us to imagine our elderly parents or grandparents, who are all in that 70s to 80s category, and tell me how many of them will fit these, will be able to check all these boxes. First, what is their level of education? Okay. Second, what is their level of income? Third, do they already have medical insurance to take care of them? Fourth, what is their English capability? You'll provide maybe a TOEFL test score or something. 5, what is their credit score in the US? Okay, I forget the sixth one off the top of my head, but I know that if I am applying for a 70-something-year-old and many times a housewife, that's not going to check boxes. So maybe your dad will qualify and your mom will not, or vice versa, and so that's a tough situation. Luckily, as of about a month ago, this public charge rule has been dropped.
Good.
Okay, I don't know if it's because of the pressure from Biden or because there has anyway been vehement opposition to it. The government was finally able to drop the case they had with the Supreme Court, and therefore the public charge rule has been dropped. So even if your case is pending and you filed the I-944 because you had to, but you're not going to pass it, they're not going to use that test anymore, and they won't even look at that part of the application and will continue to process the case.
Oh, that's good. That's good to know. Like, I mean, totally. I mean, we belong to the culture where taking care of elderly and younger is like second nature. Kind of, that's our duty. And getting to write in or review these kind of documents put a lot of mental anxiety and stress.
Right.
So that is a big part which comes along with this. No, totally a good point that you mentioned here.
Yeah.
Yeah, no, that's good to know. I'm glad they dropped down the public charges. It could have taken a lot of. I mean, it would have been another COVID on top of COVID for many people.
It wreaked havoc. You're right. It wreaked havoc on people's cases. Yes.
It's interesting. Yeah. Good. Let me see if Dr. Amit is still there. Else, I'll probably continue with a couple of questions. Maybe a couple of questions that come to my mind was like, hey, at what level you can expand this family green card sponsorship? Like, can I do it for my uncle or can I do it for my second cousin? I mean, we don't know that. So please educate us on that.
Sure. So it's really for green cards, you are sponsoring that first circle, right? You could sponsor for your parents, you can sponsor for your children, and then there's categories of unmarried children and married children over a certain age and things like that. You can sponsor for your brother, you can sponsor for your sister. But now I say you can sponsor all of these, but just like employment-based cases where I said there are certain levels, there are categories, and there are wait times, it's similar for family-based cases. Many of us are used to the parent cases, and so we think, if it's family-based, you'll get it immediately. I mean, if it's for your parents, that falls under immediate relative, and so you're able to get that green card faster. But if you're sponsoring for your brother or sister and, this adult brother or sister, that is going to take quite a while. Your wait time is quite a while for Indian nationals. And if you're considering it, start 10 years in advance. If they're even thinking about settling down with you much later,
interesting.
Start in advance, and then they can think of when the time comes, they can make a decision.
Okay, that's good. I have a curious question on this. I'm hoping you would know this as a history. In the past, this was like not taking this much time. Is that a right understanding? Like probably I'm talking 20 years ago, before the 1990s or 1980s. I think the family-based was more, hey, it was less than 6 months or less than 3 months. Is that a correct understanding?
Yeah, I'd say it's two things. One, of course, population in general has grown. Okay, that's number one. But two, there's an interesting documentary that kind of explained it really well, and it has to do with Indian children and spelling bees. And it talks about how, we all know, we see a lot of Indian kids in the spelling bee competitions, and it talks about how the 70s and 80s was really the time when there was more of an influx of Indian immigrants, and that's when that population really started to take some rise, right? And in doing that, though, because our population in India is so large, something like the green card, imagine that, you have a quota for each country, but our population of India and China are so large that you reach that quota too quickly, right? The number of people who are applying, You reach that so quickly. That's why that line is forming. And so that's why there is that longer period of time for wait for the green cards. But also think about H-1Bs. There was a time when, even though there were 65,000 cases for bachelors and another 20,000 for masters, that they could actually leave it open for months. Okay. And that lottery period was available and open for months. But it's only in the recent years, and I don't care to guess which year it was, but it's only in the more recent years that so many people are filing that they only hold it out for about a week, and you've already reached the capacity. So much so that even when they leave it open for a week, last few years, about 240,000 people apply for the H-1B, for new H-1Bs. So that quota is met so quickly that it's only having to be open for 1 week. So that's part of why these things take longer, why people have to reapply each year for H-1B if they didn't get selected, things like that.
That's interesting. That's interesting. Yeah, good, good to know. So let's talk a little more on the family-based area. So I know the nationality. I know this is common to both the employer-related as well as this one. So then, when you say nationality of Indians, does it talk to where they are a citizen right now, or does it talk to where they were born? Kind of help us understand on that.
Yeah, it does. It's the country of birth. It's the country of birth. And why that's important is, you can imagine that someone might say, hey, then let me go ahead to Canada, become a citizen, and then try to come to the US. Even that will take shorter. I might be able to do it in 5 years versus the 10 years, right? So it's to prevent things like that, to really give it a fair shake, that they go by the country of birth. Now, the only shortcut you might have, and I mean, shortcut's actually the wrong word. If you're either in this circumstance or you're not.
That's a good point. Yeah, exactly.
You're either in this circumstance or not. And that is, if you happen to be married to someone of a different nationality. So, Indians, we say, when we say Indians, we're really referring more to our parents' birth country if we're second generation, right? So if I term that as Indians, we are located in England, we're located in Australia, we're located in Africa, we're located in various countries. So if someone was born in another country, let's say like the UK, and you're the spouse, but you're born in India, you are permitted at the time of filing to use your spouse's country of birth when filing for the green card. So that can help certain people who happen to have a spouse who was not born in India. And so you can use the nationality of your spouse to look at the priority dates and where it falls. So that's a possibility.
That's interesting. I know a few people, I'll give a good example. One of my friend who belonged to, she's an Irish citizen, and she immigrated to the United States along with her family, and they are in the process of this green card. But they were surprised to realize, man, the country of birth is the most important. Me being an Irish citizen is it's not adding value here, is what they realized.
Same as a rude awakening, I imagine.
Yeah, that was one thing. But on the other side, I definitely have a good story. I have friends whose parents lived in the Middle East for some time, and that's where the kids were born. But honestly, they had no intentions to stay put there for a long time. But they immigrated back to India. Over the time, they managed to come to the United States. So the place of birth was a good thing here. It was an added advantage here because it was Bahraini nationality.
Yeah, I think that rule has equally helped and hurt people.
Oh, really? Right? Tell us just how it has hurt, please.
No. What I mean is by hurt is, like you just mentioned, right? That if somebody has really lived in Ireland for most of their life and has become a citizen, they thought that they could use that, but instead they are of an Indian background, Indian birth, and so unfortunately they had to use that priority date. So it's done both. I've seen both.
Yeah, that's right. That's right. Yeah, as you said, we cannot change the place of birth, right? After a long time,
you cannot. Yeah.
Yes, that's a good one. That's a good one. A couple of things I want to ask you from a family-based aspect, or even in general. What are the common mistakes people do when they go about filing for these processing, whether green card, maybe start with green card, and then probably you can drill down or drill up for citizenship or even to the H1Bs backwards. Tell me, because green card is the most common thing, right? So tell me what common mistakes people do and how they can prevent doing that so that they can be a little more cognizant.
So right now, I'm speaking from the experience of when I used to work for a company and what I saw employees doing. I was an immigration consultant, and so I had employees asking, hey, can we do this? And can we do that? Because they want to get to that green card as fast as possible. I had one employee who pushed so hard for an EB1 green card. He wanted both that EB2 filing and the EB1 filing because you're allowed, you can have more than one green card case filed, okay, with that employer. But that employer said, look, I'm only going to file one. That's the budget I have. So, listen to the advice of the person, whether it's your immigration consultant or your attorney, who is evaluating your case and looking at it to say, sometimes you have to hear it. I'm sorry, you're not going to fit under extraordinary ability. You're not going to fit under outstanding researcher for these reasons. We need to fit so many criteria. You only fit 3. And then they're like, yeah, but I wrote this one paper, or I got this one award. I mean, that's great, but it's not nationally acclaimed, internationally acclaimed. And so it's hard to tell your employee, I'm sorry, you are not at that level, but stay in the EB2. That's going to be better for you rather than getting denied. And so I think the common mistake is to push a little too hard with your employer for the wrong green card, purely because of time. Now, I say that, but then I also say you are your best advocate. Frankly, yeah, I would say we tend to, as a society, to be pushier with our employers. But at the same time, I'm not saying you need to be pushy. I'm saying you know your case the best. And if you feel there is the person who's working your case, or not even working your case, sometimes your manager or your HR, they do not understand the complexity of your immigration case. Your employer, their immigration consultant sometimes understands it or does understand it, but the manager that you have to convince and the HR coordinator you have to convince may not understand it. So it is difficult as an employee to have to deal with so many people to get that green card that you need so badly. And so I say sometimes break it down for them, provide a visual of timelines, because some people's cases are confusing. I recently had somebody who called to consult with me as an attorney to advisor just for her. The company already has their own immigration attorney, but she wants to know, hey, is my employer wants to do this, but then this other option came up where my husband got this other type of green card option. I think it might be faster for me to process our green card under his company than it would be mine. That's not a question they're going to talk to their employer about, because you also have a spouse's employer involved. So they called me and we talked about it. Now, the reason it's confusing in something like that is timelines jumped. And so one was actually ahead, then later the other one was a little bit more ahead. So your employer is not going to understand that. So I said, kind of draw it out for them and show them the timeline so that they can visualize it and you can explain it. Really open their pockets to do what you need.
Oh, well said, well said. Yeah, that's a good point. And do people, again, curiosity question. So from a family-based aspect, are families allowed to file for green card from a wife's employer based as well as the husband's employer based, or would you suggest, hey, just go with one approach?
No, do go with one approach. You don't want to simultaneously have two cases going on like that. Right. Do go with one. There should only be one adjustment of status. You might have two I-130s or I-140, in employment-based I-140s. So both your employers maybe file the I-140. But if you realize that one can file sooner, then there should only be one adjustment of status. So if you think the spouse's case is going to be faster, then both should file with them.
With the spouse. Okay, got it. Makes sense. I see Dr. Amit is here. Amit, any questions that you have?
Yeah, no. Yeah, you can just call me Amit, Lakshmi. So thanks again, technical things. But this is an offbeat question. I'm sure you've covered most of the questions we discussed. Uh, I've come across as a family-based person. Can I sponsor my sister if she's already in the United States and she's my sibling? And how long does it take for her
Yeah.
who's already in the US and who's not in the US? So it's a two-part question.
Right. So we did talk a little bit about it. We talked about the family members you're allowed to sponsor, but with a sister's case, the case is going to take much longer. It's not like sponsoring your parents or your minor children. It's going to take a lot longer for a sibling. So in that scenario, you would want to wait to sponsor till from their home country, because it's going to take a number of years. So you can file their I-130 right now, your petition, but they're not going to be eligible to file their adjustment for years. When that priority date becomes available, they can file from their home country at that time. It's not advisable for them to wait that out in the US, because that means they're overstayed on some visa and now they're going to be undocumented and be subject most likely to some type of removal proceeding simultaneously. You don't want that type of trouble. So I would say it's best in that type of scenario to file from the home country, and it'll be later.
Got it. Got it. Makes sense. I do have one question that keeps coming from students, because I work a lot with the students community. How long the OPT to H1B transition? Help me, give us little tidbits on that.
Okay. So if I were a student on an F1 OPT working with, I'm working already with an employer because I have an EAD. Early on in my employment, I would explain to them what it takes to keep me employed at their office. Okay. The reason for that is when you have that OPT, it's only for 12 months. Unless you're under the STEM category, then you can have another extension. But with H1B, it's lottery based. So when you are entering an employment with F1 OPT, you already know that you're really only guaranteed employment authorization for so long. And so you need an H1B to keep you employed there. And you want to make sure your manager understands that. So you say to them, this is what an H1B is. This is the lottery process. I might not even be selected in the first round. So we got to apply from the very first year. And so you apply that first year. If you don't get selected and you had a STEM extension, you're lucky because you have a second year in which you can apply. So you want to start that process early on.
Got it.
Now, it's a complicated answer when you talk about how does the switch work from F1 OPT to H1, only because it depends when your OPT started. And this is the simplest way in which I can explain it is, you're now putting your name in the lottery in March. Okay, the selection is going to happen by April. Once you've been selected, if you're somebody who is on an F1 OPT, even if you are selected and approved, the first day you can start working using the H1B visa is October 1st of that year. At the very minimum, October 1st is the earliest date. Even if it's approved by July, the visa does not go into effect till October 1st of that year. So what if your F1 OPT expires in the middle from the date that you applied for this H1B and the date that H1B actually goes into effect? There's a thing called cap gap.
Okay.
And so, yeah, I don't want to go too deep into it, but there are, if you're selected, it'll allow you to remain work authorized for a certain period. If you are, things like that, it'll go on like that. And depending on where you are in the process, the cap gap will cover you.
Okay, good. No, thank you. I know this is a vast area and lot of avenues to learn. But yes, I'm looking at the time. I know precious time. When time flies, when certain interesting topics keep going, right?
Yeah.
So yes, thank you. Thank you so much for taking the time to talk to us, Dr. Amit. Anything you have as a last word or a final say? Okay, I think we lost Dr. Amit.
No, I think Lalita, fantastic job. That's covered. We've covered vast number of topics, and thank you so much for your valuable time. And everybody will have an email where to contact you, and we really value your valuable info. And I know it's very challenging to put complex topics, but thank you so much.
Yeah, thank you. Thank you, Lalita. It was amazing. And I'm sure there will be a lot of, as you can see, we have the email address of yours here. So people, whoever is watching, if you have further questions,
Yep.
tie to immigration, by all means, feel free to reach out to Lalita. And thank you so much for taking the time. I know this is like the hot topic in everyone's mind, or many immigrants'
Yeah.
mind.
Yeah. I mean, immigration is something unlike other areas of law that changes every day.
That's
So it is a hot topic. It's always best to talk to somebody who knows about it. But I really appreciate you inviting me to speak on this subject. Thank you, Lakshmi. Thank you, Dr. Amit, and President Amuda, as well as all of the Chamber of Commerce. Thank you so much.
Thank you. Over to you, Amida.
Let me unmute myself. Thank you, Lalita, for sharing us your great experience and insight on this immigration process. It was really wonderful. Thanks, Lakshmi and Amit, for moderating the event very well. For those of you who watch the recording, please view the recording. Also, if you have few questions, you can send the email directly to Lalita, or you can email our chamber's email as well, info@IndoUSNEFL.org. Reach out to us for any immigration related questions, and we'll try our best to respond to you back. Thanks, everyone. And let's connect again in our next event. Have a wonderful evening. Thank you all.
Thank you.
Thank you.
Thank you, everyone. Thanks for your time. Bye.
Bye.